Good morning, everyone, and welcome to another installment of our iTOOsday. I'm very delighted to see everyone here today, joining us today for what looks like to be an informative and insightful session together. Today's session delves into the classification of locum healthcare professionals, the specific legal frameworks and regulations that govern employment relationships and risk mitigation measures. Throughout our discussion today, we will draw your attention to practical implications of these legal distinctions and explore how they influence professional liabilities. Joining me today, we have Jean-Paul Rude and Maphumulo from Adams & Adams. JP, who we call him in the office, is a partner in the insurance division at Adams & Adams. He has been with the firm since 2008 and was promoted to partnership in 2014. He specializes in insurance law, medical law, and general litigation with specific focuses on medical negligence, professional and public liability, general liability litigation, general litigation, and regulatory complaints. Mtho is a senior associate in the insurance department at Adams & Adams. He commenced with these articles at Adams & Adams since 2016 and has been with them since. Mtho has a passion and interest in insurance law, financial sector laws, dispute resolution, and general litigation. His areas of speciality include insurance law and financial sector laws, professional negligence, public liability, general liability, and alternative dispute resolution and general litigation, and regulatory complaints. So before I hand over to JP and Mtho, please note that today's session does not delve into policy response or interpretation, but is merely more of an informative and engaging section. It is important to remind our brokers that we as iTOO, under the mid-mill policy, do not cover locums and independent contractors. So with that being said, over to you, JP and Mtho, and let everyone enjoy the session today.
Thanks, Alex. Morning, everyone. Before we get started, maybe I can just start with some housekeeping from my side. I will be presenting the slides today. In brief, I'll be touching on the common law, legislation, policy, and how this then all plays out in a very interesting case study, which was before the CCMA of all places, which we'll delve with, which we'll speak to a bit later in the presentation. To close off, I will then also deal with a few risk mitigation measures which can be adopted. And then the presentation should be roughly about 30-40 minutes, which should give us enough time for a Q&A session, at which point I will then hand over to my learned colleague Mtho, who will then field any questions that you may have following the presentation. If I may ask that during the presentation, maybe just to hold over on any questions and wait for the Q&A. We should have enough time in the Q&A to address all questions. If we do run out of time for some other reason, then we'll obviously get back to you afterwards as well. So all questions will go answered. If it's not in the presentation, it will be afterwards. So without any further ado, can I just confirm before we start that everyone is seeing my screen?
Okay. Yes, we can see it.
All right, so today we're busy with the legal status of locums, when they are considered independent contractors and when they are considered employees. I just want to see the next slide. Okay, so a principal can only be held liable for the wrongs of an independent contractor, or cannot be held liable for the wrongs of an independent contractor unless the principal is personally at fault. Now, this is trite law in South Africa, and you would see that I've underlined the personally part, and the next slide will delve into this. Now, how can a principal be held personally liable in South African law. Now, I've given a few examples in this slide. One would be that if a principal employs a locum but does not verify the credentials of the locum, if there are concerns raised regarding the locum's conduct or competence, and these are not addressed by the principal, or if the locum is not provided with the necessary equipment, and in so doing, they contribute to negligent patient care. Now, when we drafted this presentation, it was done in a medical negligence space or a framework, but it could equally apply to any other sector. And to give you an example of this, I would think of, say, for example, I am the owner of a shopping mall. And as the owner, I have a responsibility towards all the patrons in terms of their security, for example. And I employ the services of an independent contractor to attend to the security in the mall. My duty is not only towards the patrons, but also obviously to all the shop owners that are leasing premises from me. And for example, I employ ABC Security, but I haven't checked the credentials of the security company, and it transpires that 3 or 4 of the guards are involved in a criminal syndicate, and the shopping center gets robbed. Some of the shops get robbed. I would then be regarded personally at fault, despite employing a independent contractor, i.e. the security company. If I did due diligence and the necessary security checks were done, we verified their credentials through other means. We checked up on other people that have employed them previously. In those circumstances, if an incident transpired, unless I was personally at fault, I wouldn't attract any liability. Then moving on to the next slide. So if a principal is found to be personally liable, and the locum is also liable, we speak about joint and several liability. There's a joke in the legal industry where they don't speak about joint and several liability. They speak about joint and severe liability, because the implications of it is quite profound, and I'll get to those now. So both the principal and the locum are liable for the patient's damages. Now, to get back to a medical space, and unless a court would apportion blame between the principal and the locum, the patient can recover their full damages from the party with means. So, for example, if I run a medical practice and it's a well-established practice doing financially very well, and I've employed a locum, but I haven't checked the locum's credentials, and the locum as treatment is under the standards of what can be expected, and a patient suffers damages. What can happen in this scenario is the patient can hold us jointly and severally liable. But say, for example, this locum, has just started working, doesn't have any means, is still basically servicing debt from university in terms of his or her studies. And, any recovery prospects in respect of this locum is virtually zero. What the patient can then do under those circumstances, they can recover their full damages from the practice, the party with the means. And then in such instance, the party with the means would have a right of recourse against the party without means. But I mean, you sit in the exact same position as the patient, because you still sit in with a locum that will more than likely not be able to pay you back for the damages that you've paid on their part. So whilst you do have a right of recourse, theoretically, in practice, it basically boils down to nothing, because you aren't able to recover from the locum. So moving on to the next slide, and an important question, and basically what we're discussing here today is, are all locums regarded as independent contractors in the eyes of the law? So in other words, you employ a locum. Is this locum regarded as an independent contractor, or is there a possibility in law that the independent contractor can be found to be an employee, which has significant consequences for the principal, if an independent contractor is regarded as an employee as opposed to an independent contractor? Now, we'll have to look at what the law says on this, and Section 213 of the Labour Relations Act, as amended, defines an employee as any person, excluding an independent contractor, who works for another person or for the state, and who receives or is entitled to receive remuneration. The second leg is quite important, and any person who in any manner assists in carrying on or conducting the business of an employer. So you'll see the definition is quite wide as to who can be regarded as an employee. And in practice, we often find quite a few disputes over whether someone is an employee and whether they're not an employee. Now, an independent contractor normally has certain traits which are giveaways that they are independent contractors and cannot be regarded as an employee. Now, I've listed a few of them on this slide. It's not an all-inclusive list, but it gives you a good idea as to what are the traits of an independent contractor. Now, the first one is, and importantly, independent contractors normally are able to control the way they work. The principal does not indicate to them, how they are supposed to work, the hours they're supposed to have at the office. They normally self in control as to the hours, the way, the manner they work. That's an important one, and we'll get into that a bit later. They can also offer their services to anyone they choose, not limited to the principal. They normally have a number of clients, the principal only being one of a number of them. And for example, they are not limited to the client base of the employer or the principal. They can choose anyone they work with. They set their own rates. They're responsible for their own taxes. They cover their own business expenses. And importantly, they procure their own insurance. So the common law has developed a few tests for an employment relationship, because in practice, like I mentioned, there is often a dispute as to whether a person is an employee or whether the person is an independent contractor. Now, over the years, there's been a number of judgments which has formed the basis of our common law, where a number of tests have come to the fore as to when someone can be regarded as an independent contractor and when they can be regarded as an employee. Now, one of the tests is the control tests, where the courts would look at the control the employer exercises over the person when performing work. So that's the control test. Then there's the organization test, where they look at, is this person integrated into the business, or are they just an accessory? So, for example, an independent contractor would not normally, be on the payroll of a business. They would not normally have to attend the training that a business normally offers in terms of or that the employees need to attend. They normally would not abide to all the policies and procedures. I accept that there are some policies and procedures that a principal or the employer would expect of an independent contractor to follow, but it definitely wouldn't be all of the policies and procedures. Then there's the economic dependence test, which is also another quite important test. Is this person economically dependent on the business for their survival? I.e., is this principal the only person they do work for, that they don't have another client base? If they're not, getting work from this principal, they basically won't be able to survive, and they go under. Now, it's important to note that not one of these tests, there's no single test which is favored by the courts, although the control test is often utilized by courts, but it's by no means favored. But it's a good indication of whether a person can be regarded as an employee or whether they can be regarded as an independent contractor. Now, NEDLAC's Code of Good Practice has also introduced a further test, while not expressly stating so, and it's a new comprehensive test considering the real relationship between the parties, and you'll see I've underlined notwithstanding the contract they have entered into. Now, entering into a contract with an independent contractor is one of the risk mitigation measures that can be adopted, which I will address towards the end. But it's by no means a fail-safe in the sense that just because you have a contract of employment with an independent contractor does not factually mean that this person is an independent contractor. And that's what the courts often look at, is what is the factual situation, notwithstanding any contract that has been entered into between the parties. Now, there's an important case that happened in the CCMA of all places, and it was a matter of Dr. Miller versus Chela Healthcare. Now, the background to the case was the following. Chela is a healthcare company rendering health services to the mining industry. Chela entered into a service agreement with Dr. Miller, requiring him to perform occupational surveillance on mine employees. So in Chela's mind, Dr. Miller was an independent contractor and by no means an employee. Later, Dr. Miller was dismissed. In Chela's mind, the contract was terminated. In Dr. Miller's mind, he thought he was an employee, and he claimed an unfair dismissal and referred the dispute to the CCMA. Before the matter could be heard in the CCMA, Chela raised a jurisdictional point denying any employment relationship between the company and Dr. Miller. And the commissioner found the following. So the commissioner found that Dr. Miller rendered personal services to Cela, who controlled the way he worked. Dr. Miller was economically dependent on Cela as his only source of income. So if you think back to the common law test, the economic dependence test, Cela provided Dr. Miller with the necessary tools to perform his work to the standards set by the company. And then this is quite an important one. Upon the death of Dr. Miller, the contract would terminate, which was not necessarily the case with a truly independent contractor, because the contract could survive in those circumstances. And the commissioner ultimately found that Dr. Miller was not truly independent or able to run his own practice, and was found to be an employee of Cela. So this is quite a recent and important case study, which gives you an idea that despite any contract that was entered into between the parties, the courts look at the factual situation, and it's the factual situation which is important, because that may reveal that the relationship is actually, an employment relationship, as opposed to being one of an independent contractor. So now getting down to the ways in how to mitigate the potential risk to you as a principal of someone being found as an employee. I've listed a few here, but again, they're not exhaustive. There could be various other ways in which to mitigate the risk. This is just a few. So the first one is obviously to enter into enter into a contract, which clearly defines the nature of the relationship. But as I've stressed, the courts look past the contract. So the contract is by no means a be-all and end-all as to what the true nature of the relationship is. So a few ways in which you might be able to mitigate the potential risk is by avoiding dictating the hours worked, methods, or tools used. Avoid offering employee benefits to an independent contractor. Avoid an exclusive type of relationship. Allow the independent contractor to service other clients and not work exclusively on your clients as the principal. And then also to avoid a continuous or indefinite engagement, where there's no end period towards the contract. The person is employed indefinitely for a number of years. If that is the relationship, you run the risk of a court finding that there's actually an employment relationship as opposed to an independent contractor relationship. So what legal recourse is there in the case of ambiguity, as there often is? Like I say, this is quite a contentious point in our law, and there's a lot of disputes regarding whether someone is an employee and whether they are an independent contractor. Now, normally, if there is a contract of employment, it would usually provide for some sort of dispute resolution, whether this is an arbitration, for example, or mediation. So a contract normally provides for some sort of dispute resolution. If the contract for some other reason doesn't provide for it, and there is a dispute over whether someone is an employee or whether they are an independent contractor, the court can also be approached for a declarator. Now, what that basically means is that any party to that relationship can bring an application to court and for the court to give guidance as to what the court believes the true nature of the relationship is. So if, for example, a principal has employed an independent contractor and believes that to be the case, they can approach the court if there is a dispute over the nature of the relationship to get clarity over whether this is really an independent contractor relationship or whether the court believes it to be more an employee relationship. Now, we've made actually quite good headway in respect of this topic, and it leaves us enough time for a Q&A, which I indicated will be addressed by Mtho. Now, Mtho's a litigator and a senior associate in our department, and he's well versed on the topic and will be able to handle any questions that you may have stemming from the presentation. So without any further ado, I'm going to stop sharing my screen and then hand over to Mtho, who will take it further from this point.
Good morning, everyone. Thanks, JP. Thanks, Alex. If there are any questions, I am happy to answer. There is one at this stage in the chat box, which I decided to wait until you are done and not answer in the chat box as well, just for the benefit of everyone. So the question there is, given that a locum may not have anything in the case of liability attracting to them based on their actions, would it be advisable for a practice to enter into an agreement between either locum, independent contractor, and insist that insurance is in place before ontake? And my response to that, and I think JP did under his slides where he discussed the mitigation of risk. The first point there, which basically states that there has to be a contract. As much as there are legal tests, obviously, to see in reality and in practical terms whether a person, a locum was an employee or, an employee or a locum, it is, in my view at least, crucial to have a contract regulating the relationship and because even if there's to be a litigation or a dispute resolution of some sort, that was to ensue from that, it would be of value. It would be of value to have that contrast, because that will be your point of departure to really try and ascertain the true nature of the relationship between the principal and the locum. So my answer to that, it would be it is advisable to insist that the insurance is in place before the ontake.
Thanks, Mtho. Are there any other questions? I think I saw some hands earlier on.
I think so too.
Shemaine, I see your hand is still up. Do you have a question for us?
Alex, there's a question on the chat.
Okay, so I think previously when we started the session, we had just disclosed that today is not a matter of I2 policy response or interpretation. So I think today we're just dealing with the topic at hand. And then if there's any other questions pertaining to policy interpretation and response, that can be directed at us in underwriting, and then we can then deal with it offline.
Alex, there's a question in the chat. I don't know if you can see it, or would you like me to read it?
I think I just answered. Which one is this one?
There's a question. It says, in the case of a medical locum, the hours that they work would be dictated by the employer. Does this make them an employee?
Okay.
Not necessarily. In terms of the Health Professions Act, it prescribes the period of 6 months. Well, that is now the duration that a person regarded as a locum can serve. But in terms of the hours, it would not be a determinative factor to say that the hours were regulated by the employer. But if it does come to a stage where those tests that were explained by JP earlier, it may be a factor to take into consideration, but by no means is that determinative of whether the locum is an employee or independent contractor.
Okay, thanks, Mtho. And I think the follow. It seems like it's also a follow-up question where can you explain the max hours allowed? So I think that would have been covered by your answer. Charmaine and Liz, do you still have questions? Because I see 3 hands up.
No, I'm okay, thank you.
Okay, thanks. Johan? Charmaine? Okay, I don't see any hands up still. You can send through your questions through to the chat box if you still have any other questions.
Okay, so we have 2 other questions.
Okay.
The first one says, please advise on the benefits of having locums on board. And the second one says, do they outweigh the benefits of an independent contractor?
That doesn't strictly fall within I would say the legal space of the thing. The legal space. I think in that case it's more of a business decision, and probably to be determined by, well, from practice to practice, looking at the surrounding circumstances of each practice and all those factors. But that's more of a business question, which I'm not well positioned to thoroughly and extensively reply to. But I mean, those who run practices would know for their specific practices whether it's better to go with a locum or independent contractor.
And Mtho, maybe just to add on, I see there's a bit of confusion. Just a locum and an independent contractor are the same thing. They're just different names, but it boils down to the same thing. A locum is, in other words, a locum is an independent contractor.
And then, Mtho, there's another one. If a locum bills for their service, are they then termed an independent contractor?
Well, it's one of the factors that will be considered if ever a dispute was to ensue. But an independent contractor is expected to submit invoices to the practice principal. So it would be a factor. But again, it will not be conclusive, but it will definitely be an indicator, one of many other indicators whether they are an independent contractor or a locum.
And then the follow-up to that is, who would be responsible for the legal claim?
Whose legal claim now is that independent contractor?
Yeah.
Yeah, well, I think JP touched on that earlier. That would be for the independent contractor because, at least in my experience, policies exclude cover for independent contractors.
Okay, there's another one. I think it's more of a clarity seeking. Locum acts for a service provider, independent contractors for themselves. So,
Locum acts for a service provider, independent medical negligence legal claim. It's just that last part. I'm not sure if I am following.
yeah.
Sorry,
Ranesh, can you just, sorry, Ranesh, can you maybe just relay your question so that Mtho can respond to it? And while we do that, Mtho, there's another one. If a contract states that a locum is an independent contractor, can the other contracting party still be considered an employee despite the clause?
Okay, if a contract states that a locum is an independent contractor, can the other contracting party be considered employer despite? Yes, and that goes to those tests that JP spoke about. So you may have a contract that says this is a principal, it's an independent contractor relationship. But then the court would then look at, in reality, what was the arrangement and how they went about doing business. And if those indicators in terms of those tests dictates that that person is an employee, then that person, the court will look beyond just a piece of paper that says the person is an independent contractor.
And then the next question, Mtho. Sorry to bombard you. They're coming in.
It's all right.
The next one, I think it was also touched on. What are the disadvantages of being a locum?
Well, one of the disadvantages obviously is that if you are a locum, you may you may be liable for, you may attract legal liability. That's a risk that is associated with being a locum. Maybe JP can just expand also on that if there is anything that he can think of as a disadvantage of being a locum.
Yeah, thanks, Mtho. I think you were correct in the first instance by saying, it really depends. It's a business decision. So it's not really a legal decision, but one of the legal consequences you correctly point out is, that you could possibly be held legally liable should, you mess up in any way.
Yeah. And then next question is my interpretation correct? The way to interpret an employee or an independent contractor would be applicable in various industries and not specifically medical.
Absolutely. And that's what JP alluded to earlier on, to say, although the discussion is more leaned towards the medical space, it can also find application in other sort of industries. So yeah.
And then next one would be, we work with several IT businesses and they use independent contractors to deliver their services. we understand that the insurer will indemnify a client, but will have a recourse against the independent contractor. Is this correct?
Can we get that again? Sorry, Alex.
Yeah, so we work with several IT businesses and they use independent contractors to deliver their services. We understand that insurer will indemnify our client, but will have a recourse against the independent contractor. Is that correct?
Well, that is correct. If well, the first instrument to look into it would obviously be your policy, but that sounds about correct to me. Yeah.
And then, so yeah, what steps can regulatory bodies or authorities take to address the misuse of terminology and clarify distinctions between locums and independent contractors?
Can we get there again? Sorry, I don't know if
Are you
the
able
sequence
to
of I'm not sure if the sequence of questions on my side.
I think
It
maybe
is
just
better
scroll
when
down
I
because
see.
they've just come in now.
Okay.
Yeah, so I see that this one was directed at 10:39 a.m. I don't know if that will help you by looking at the time.
10:39. Oh, I see. Okay.
Yeah.
Okay. What steps can regulatory bodies, authorities take to address the misuse of terminology and clarify distinction between? So it's that's a very good question, but it becomes very difficult in the sense that the regulators can put in the regulations and all that, but at the end of the day, when a dispute ensues, then it becomes a matter of interpretation by the court, which I think, well, I mean, obviously to have well-defined regulations, that's the first step, but it doesn't necessarily end there because the courts still have to interpret these. And I mean, we can take an example of, obviously of the well, there are regulations which would say, and also like legal distinctions between your independent contractors, your well, and the other, well, your employee, your independent contractor. But when you get to court, the court may then look beyond the piece of paper that stipulates who is what in terms of the relationship. Then go to those tests by JP again. They look at the real practicalities and the realities of the relationship. So I mean, the best that the regulatory bodies can do is to strive for to achieve, you know, well drafted and crafted pieces of instruments, but that would not necessarily destroy, if I can call it that, the possibility of the courts coming in and interpreting things the way they deem appropriate in each particular case.
And then the next one would be, how do healthcare professionals themselves perceive and navigate the differences between being a locum and an independent contractor?
Well, how that would ordinarily go about would be really the contract between themselves, the principals, and the people they leave their practice with for that temporal period. Then they decide at that point whether they take on that doctor as a locum, sorry, as an employee or as an independent contractor. So that's the best. I mean, and also, sorry, beyond the contracts, then it goes to those the mitigation of risks slide by JP, where they've got to then ensure that they do not interfere as much. They do not. Well, there are certain policies of the practice that the locums are not expected to adhere to. So it's all those kinds of things. That's how they can try and navigate between that very fine line of being considered an employee or strictly independent contractor.
Okay. And then next question is, in what ways can education training programs for health professionals be enhanced to ensure a better understanding of the distinctions between locums and independent contractors?
Yeah, thanks. That's yeah. So it's all about these kinds of sessions where the relevant stakeholders they actively partake in such sessions. They share knowledge. We try to align in the uniform our understanding of these things, and in so doing, we try to at least minimize the possibilities of these issues. And I mean, it's all about really being proactive and partaking, playing our part, and constructively trying to always navigate and find ways in which we can try to align the understanding within all the relevant stakeholders. Although maybe it remains, it remains an ideal wish to say we can get to a level where there's no misunderstanding in relation to these things. But the best that we can do is to try and proactively take part in such sessions and try to align our understanding. And yeah, that's the answer there.
Thanks, Mtho. And then let's just see the time. We've still got enough time. So if a locum is working for a doctor and there's a legal claim, who would answer the claim? And then I think the next one to that is, if an independent contractor was working for a doctor and billing for themselves, would they not have to answer or respond to the claim against them? And who sends the bill? Is they one that ultimately have to, are they the ones that ultimately have to answer the claim?
Okay, so the first part is, if a locum is working for a doctor and there is a legal claim, who would answer? We've got to go back to the distinction of whether that locum is contractually an employee or independent contractor. I'm not sure now if I'm going to answer the next part. If an independent contractor was working for a doctor and billing for themselves, would they not have to answer the claim? So sorry, Alex, and sorry to the members. If an independent contractor was working for a doctor and billing for themselves, would they not have to? Okay, so if you are an independent contractor, you would obviously you are not strictly answerable to the doctor. And your bills, maybe JP can also assist me here, but my understanding is, in terms of billing, an independent contractor has to submit a bill to the doctor.
Yes, Mthosa, to answer this question is quite a broad question, but I would go back to what I addressed earlier in the presentation. Is you got to distinguish between liability on the principal side, the versus liability on the locum independent contractor side. So a principal could attract liability, personally, if they didn't do the necessary checks in respect of the locum. So that would be one of the factors that they would look at to hold the principal personally liable. In respect of the independent contractor, if the independent contractor then also messed up, because in this case it seems like it would be a truly independent contractor who's billing the doctor for services rendered and stuff. If this independent contractor was negligent, they could also be held liable, and then you could sit with a situation where both the principal and the independent contractor get held liable, because there's all kinds of factors that would need to be taken into account to determine whether the person is really a truly independent contractor. But you know, they allude to billing here, which is one of the indications of being a truly independent contractor. So in this case, if the principal was also personally liable, both parties would be jointly and severally liable, and the patient would have a claim against both. If the principal wasn't personally liable, i.e. the principal did all the necessary checks in respect of the locum, and they employed someone who was competent, then only the locum would attract liability in respect of the locum's actions. I hope I've answered the question.
And then, do independent contractors receive the same benefits as employees?
The answer there is no. No, they don't.